Okay, good morning, everyone. Let's go ahead and go on the record in the matter of Brown versus Jamrog et al. This is file 23-36749CB. We have a motion filed by the plaintiff for a temporary restraining order. It was filed ex parte, requesting ex parte relief. The court decided to conduct a hearing. We have with us the plaintiff and her attorney, Ms. Gray. We also have with us the three named defendants, along with their attorney, Mr. Muthart. I have had a chance to review both the motion and the response. Let's go ahead and have some argument. Ms. Gray, your motion.
Thank you, Honor. Good morning. And what we're requesting today is essentially, this was Sage itself was just a kind of a shell business that had one function, and that was to manage the four businesses of the four ladies and essentially pay rent and utilities. Ms. Jamrog, as alleged in the complaint, used her position as manager of Sage to unilaterally reassign the lease to a new company that had been formed back in April, unbeknownst to Ms. Brown. The parties met back in April and no decisions were made. And certainly not a decision to oust Ms. Brown from the leasehold that all four went in and essentially contributed to about 3 years ago. At this point, we're just asking that, Olive Hair Design can go do whatever they want, wherever they want, but Ms. Brown should be allowed to operate in the space. Their irreparable injury at this point, as alleged, is the fact that she has, going into the busiest season of the year, or the busiest season for hairdressers, she now has nowhere to work and nowhere to service her clients. And so again, if the other members wanted to do something else, they were free to do that at any point, but not to the detriment and oppression of Ms. Brown, which is exactly what, unfortunately, they did by ousting her at the end of August. As a result, she has nowhere to function at this point, and we would just ask again that the lease be forced to be assigned to Ms. Brown and back to Sage and allowed to continue in that space.
All right, thank you. Let's go ahead and hear from you, Mr. Muthart, in response.
Yes, thank you, Your Honor. And I'm glad that the court's had an opportunity to review our response. So the court's aware that at this point, I guess neither party has really recited any of the applicable case law that would support the granting of a temporary restraining order. As the court's aware, it's a 4-factor test. Ms. Gray has alluded to one of those factors today, irreparable injury. Case law is pretty clear in Michigan that any injury that is economic is not irreparable, and that is exactly the injury that she's alleged here. The other factors, of course, are harm to the public interest if an injunction issues, and whether harm to the applicant in the absence of temporary relief outweighs the harm to the opposing party if relief is granted. And most importantly, I think among these is the likelihood of success on the merits, Your Honor, and that is what my my response focused upon. As I think is abundantly clear, and Ms. Gray has not argued to the contrary today, nothing in the operating agreement, Liability Company Act, requires these 4 women to remain members of this LLC for the rest of their natural lives. Partnerships sometimes break up, and in this case, the possibility that the partnership might break up was specifically contemplated at the time that the LLC operating agreement was drafted. The court is, as the court is aware, prior to the chronologically, what happened is they signed a lease. The lease provides for expiration in August of 2023. Lease further provides that if the lease is renewed 120 days before that August 31st deadline, that there's an option to renew it. The tenant has the option to renew. So they signed this lease knowing that they had this 120-day deadline before August 31st to renew the lease. Then they signed an LLC operating agreement, which states that all four of them have to agree on every decision. So they knew that when they signed this operating agreement, that their lease was going to expire unless all four of them could agree that the LLC would exercise the renewal option. And that is more than just a coincidence or a fact about the way things is. That is, in fact, specifically the quote-unquote exit clause that Ms. Jamrog asked Ms. Gray about when Ms. Gray, I believe, was representing all four of these women. She said, where's our exit clause in this operating agreement that you drafted? And Ms. Gray responded, well, your exit clause is that if you all can't agree to renew the lease, when it expires in 2023, you'll go your separate ways. Those were her words, go your separate ways, she said. And that's what happened. My clients attempted to get together with Ms. Brown. There was a discussion, and they're here. You can get their testimony, Your Honor, if you want to today. But they had a discussion with Ms. Brown, and Ms. Brown said, are we going to renew the lease? They discussed renewing the lease prior to the deadline for the exercise of the renewal option. And they said, hey, we've got some concerns and we would like to have some amendments to the operating agreement. And so Ms. Brown said, well, I'll go check on that with Ms. Gray, and nothing ever happened. And so the deadline came and went, and my clients, the defendants in this case, formed an LLC, signed another lease. They went their separate ways, just like Ms. Gray said that they could and would and plan to. That's the exit clause. The lease expiration is the exit clause. We've attached that email to our papers, Your Honor, as Exhibit 4 to our response. So the exit clause that Ms. Gray described and planned for and that everybody agreed to was actually implemented. That's what happened. And so, the idea that the lawyer who proposed that and then drafted the operating agreement based upon that, telling everybody that if you decide that you don't want to remain together anymore, all you have to do is just not exercise the renewal of your lease, has now sued 3 out of the 4 of her clients to try to enforce I'm not sure what. I mean, the operating agreement, like I said, doesn't say, that it can never be terminated. It's outrageous, Your Honor. We shouldn't be here. And there certainly is no basis for a restraining order allowing or providing for as the motion asked for, among other things, that the bank account for the LLC be assigned to Sharon Brown, that the lease be assigned to Sharon Brown. I don't know how that works. I mean, we've got a landlord in the mix, and it's impossible to do that.
It's not possible. The landlord's willing to do whatever.
Whoa. This is great.
I apologize, Your Honor.
I'll call on you. You get an opportunity to reply. All right, let's finish up. Mr. Moodhart, please.
So yes, Your Honor, unless the court has any other questions, I think, again, as I've indicated, Exhibit 4, this is Ms. Gray's email. Ms. Jamrog has raised the issue of an exit clause. My understanding of the group's decision on this issue was that you all agreed to keep on as Sage with 4 partners for the initial duration of the lease through 2023. When your lease is up, then you meet about a month before and decide whether you are going to stay in a 4-way partnership or go your separate ways at that time. That is why I left out any exit clause. And I don't know how much clearer it could be. And that's what happened. They couldn't agree and didn't agree, all 4 of them, like the operating agreement that was drafted, to renew the lease. So the lease didn't get renewed. And it isn't for lack of trying on my client's part. Then after that happened, there were 2 separate attempts by my clients in July and August of this year to communicate with Ms. Brown and say, hey, what are we going to do? How are we going to wind up this company? Both of these were sent to her by certified mail. I mean, we've got the receipts and the communications attached to our response as well. No response. The only response we get is we got sued. This should not happen, and we shouldn't be here. This is frivolous, Your Honor. Unless the court has questions, I think that's all I have.
Thank you, Mr. Moodhart. Ms. Gray, in response.
Thank you, Your Honor. First of all, I did not represent all four at the time the operating agreement was entered into. Mr. David Becker represented those three, Ms. Jamrog, Ms. Simerson, and Ms. Gibson. They had separate counsel back 2 years ago, whenever we signed the operating agreement. And yeah, the parties met in April of this year. And the parties were supposed to do everything in writing. That's what the operating agreement said. If they were going to agree not to renew the lease, then that agreement needed to be in writing and very clear. What you'll see in the letters attached to the complaint from August 8th and July 28th, there's no mention of this lease. There's no notice to Ms. Brown that the lease itself has been engaged, has been renewed in a wholly different name. I mean, this wasn't whether we're going to renew or not. There's no notice to Ms. Brown that any renewal is happening. That, the assumption at that point is that, yes, things are being renewed. There was no notice to her that this lease was going away, that she needed to get out until August 8th was all your belongings have to suddenly be removed by the 31st. And so that's why we're asking that this court allow Sage to continue in this, is because Sage had the right to renew the lease, not Miss Jamrog individually or this new company, Olive Hair. Neither one of them had the ability. None of them would have known that this lease was even available, but for Sage's relationship. And to do this at the detriment of Miss Brown and then not tell her anything until, by the way, you have to get your stuff out and we're changing the locks next week. That's where we sit, and they're going to run away with the benefit of the four of them having built this space to operate in. There is nothing in the agreement prohibiting them from forming Olive Hair and from going elsewhere to do so. We're just asking that this lease that was fraudulently renewed in Miss Jamrog's name individually against Sage. Again, she used her position as manager of Sage to negotiate with the landlord a lease for herself. That's the action that we want undone, that we want the lease assigned to Miss Brown. She's prepared to take it over and continue paying for the lease going forward without the other ladies. But, for them to have used their position to undermine and oppress Miss Brown as a member of the LLC is the fraudulent and oppressive conduct. And there is likelihood of success on the merits because there was an operating agreement that said all four have to decide one way or the other. Yes, they met in April, but there was no writing. There was no amendment. They continuously like to do business without putting anything in writing. And that's what they did in this case. And nobody, again, told Miss Brown that she was going to be losing her chair, that she could, nobody told her, hey, you probably should not make any more appointments into the Christmas season because you're not going to have a chair here in a week. That notice didn't come until late, until she had like 7 days to leave. So again, we're just asking this court assign the lease to Miss Brown, allow her to continue operating in that space, and then let the rest of the chips on this dissolution of corporation fall where they may.
So Ms. Gray, let me ask a factual question that you can help me with. The lease expired by its own terms, and we're discussing the extension of that lease. Obviously, had Sage remained intact and the parties agreed, and they agreed that the matter was going to be, the lease was going to be extended. That could have been done, but that didn't occur. So is this a new lease that was signed with the defendant's new organization, or is it actually an extension of the prior lease?
My understanding, and we have not seen a copy of this new lease, is that according to Mr. Moothart's letter attached, I think, to my amended motion was, or the ex parte motion, admits that it was in the new company name, Olive Hair.
So it sounds like it was a new lease, though. That's what I'm concerned about. All right.
Yes. I believe our clients have formed a new LLC and have entered into a new lease for the space formerly occupied by Sage.
All right. That would be consistent with the way I read the materials. I just wanted to make sure that was the case. Anything else, Ms. Gray?
No, nothing further. Thank you, Your Honor.
Mr. Moothart, anything else from you? You're on mute.
I think that the court, sorry about that. I think the court has hit on the point here. I mean, when we entered into this operating agreement that said we all have to agree on every decision we make, and all those decisions must be in writing, we already had a lease that was going to expire by its own terms. And to suggest that somehow we needed to agree not to renew it in order for it to not be renewed is the opposite of what the documents say. The lease is already going to expire. We've already got advice from, we thought our lawyer, I mean, Ms. Gray said she wasn't representing us. I mean, the email surely doesn't say that. She's drafting an LLC operating agreement for everybody. We've got an email from her that says the exit clause is, if you all get together and make a decision to renew or not renew, that's your exit clause. But irrespective of any of that, like I said, we've got a lease that's in place. It's going to expire if we don't do anything. Doing nothing is not a decision that needs to be documented in writing under the LLC operating agreement. We've already made the decision. We have a lease. It's going to expire. We all signed it. We can renew it if we want to. That is an elective decision that the LLC could make at some point in the future, but it doesn't have to. And then when you sign an operating agreement that says in order to make that elective decision in the future that you don't have to, you all have to agree on it and document it in writing. That means that if you don't all agree on it and document it in writing, the lease is going to expire. And once that situation, that event came and went, the lease was going to expire. And yes, my clients formed a new LLC and signed a new lease. Just i.e. went their separate ways in exactly the way that Ms. Gray's email to us, Exhibit 4 to our response, contemplated. And
all right, thank you. Ms. Gray, do you have anything else? You get the last word on this.
No, Your Honor, thank you very much.
Actually, I get the last word on this now that I think about it. We have a motion that's been filed by the plaintiff in this action. The plaintiffs and I should say the individual plaintiff and the defendants are all members of Sage Hair Studio LLC, a organization that was apparently set up to operate and manage a hair salon and also as part of that be involved with the lease of property where the work would be performed by the four members. The plaintiff has now filed a complaint for what is essentially shareholder or member oppression, alleging, among other things, that there's been a breakdown of the organization, that the individual plaintiff has been unable to access the accounts associated with the LLC, and also has been precluded from being able to operate her business her efforts as a hair salon stylist since I believe late August. The motion was verified as an ex parte motion by the individual plaintiff. The defendants argue that the basis for the lease, which was under the name of Sage Hair Studio LLC, the lease itself expired in late spring, early summer of this year, and that the LLC did not extend that lease. Therefore, the leased property was available for them to go ahead, meaning the remaining defendants, meaning the defendants, to be able to enter into a new lease, which is exactly what they did. The plaintiff is seeking reinstatement of her ability to operate at the facility. The leased premises, she apparently does not have, based on her verification, does not have a location where she is able to perform those services at this time, which is resulting in economic damages to her. This is a motion that's brought pursuant to 3.310 sub B, which deals with temporary restraining orders. It was filed ex parte. The court set this matter for hearing. We've now had a hearing on this matter. the court has listened to the arguments of the parties and, of course, reviewed the pleadings and the materials that have been provided by the parties. There are several factors that the court has to analyze with regard to a temporary restraining order. Those factors deal principally, at least relevantly with this particular matter, with the damage to the individuals involved, relative damages to the individuals involved if the order is not granted. In this case, clearly that weighs in the benefit of the plaintiff, as the plaintiff has indicated she is not able to exercise her business or to operate her business in the same manner that she was before. She's not able to take reservations one would suppose, based on the information, advise potential clients where they might be able to get the services performed. This going into what they've indicated here today is the busy season for hairstylists. So there certainly is some economic impact to the plaintiff for failure to, for her not being allowed to use space at the former facilities of Sage Hair Studio. The second issue that I think is relevant for the court's review is the likelihood of success. Here, I think that the plaintiff has failed to demonstrate a likelihood of success on the matter, specifically because, as the court questioned, it was clear that the underlying lease was not renewed. It is clear the underlying lease was not renewed by Sage Hair Studios. Not surprising, as it appears the parties were not able to agree, and their operating agreement does require that all four agree in order to be able to extend the lease or take any action, frankly. Query whether or not that was a good decision at the time of the formation of the operating agreement, but that's not an issue before me today. The bottom line is the agreement is what it is. All parties must agree they did not. As such, the Sage Hair Studio LLC extension was not executed or was not performed, and essentially the property went technically vacant and was, it appears to the court anyway, properly released by the defendants in their new organization. So as a result, it is not clear to me by a preponderance of the evidence that the plaintiff will be successful on the merits in this matter. It does appear that the defendants had the ability to take the action that they took, and in doing so did not necessarily oppress, at least with regard to that particular issue, the interests of the plaintiff. Having said that, we haven't even talked about the other matters that have been raised in the underlying summons and complaint, including, for example, access to the assets of the LLC. Those are things we'll have to deal with later. But in terms of requiring through a temporary restraining order that the plaintiff be reinstated to the subject property, that is the property that is subject to the former Sage Hair Studio LLC lease, and now the new entity formed by the three defendants. I think that property is at 512 West 14th Street. The court finds that the plaintiff has not met its burden, and as a result, I will not execute a temporary restraining order on this matter. Can we get this case into mediation? This is a case that should mediate out. Do we have anything scheduled, Ms. Gray, at this point?
No, Your Honor. The defendant has until October 31st to file an answer to the summons and complaint, at which point we will be on the contested case docket and likely get those orders.
That's correct. Okay. Well, once we get an answer in, we'll issue a scheduling order, and hopefully the parties can get together and get this matter resolved. Mr. Moodhart, if I could get an order from you with regard to my decision today.
Yes, Your Honor. It will just state that the motion is denied for the reasons set forth by the court on the record, Your Honor.
Okay, very good. Take care, everyone.
Thank you, Your Honor.